Hey, good morning, everyone. I thought I would do a video review, or hopefully a quick one this time, for Chapter 5 on civil rights. Chapter 4 related to civil liberties. And what's the distinction again? You kind of should know the distinction, but I know that most of us, including lawyers and civically minded people, often use those terms interchangeably, but there is a distinction. Civil liberties are those kind of unalienable rights that we think of as natural rights or human rights that the government really shouldn't be able to mess with or interfere with or restrain unless they have a very compelling reason for doing so. And sometimes they do, but it's rare. For the most part, we think that people should have the freedom to speak their mind vis-a-vis the government. The government should be able to put a chilling effect on our free speech. We should be able to freely practice our religion. We should be free from unreasonable searches and seizures. We shouldn't have a government that doesn't do or provide due process when it takes away our property. All of those things that we think of as civil liberties. So what's a civil right then? Most of us use the term interchangeably. A civil right's a little different. This is where the government actually takes a proactive set of action plans to make sure we have equal access and equal application of law, no matter who we are, race, color, creed, national origin, whatever we identify ourselves with. It's usually immutable characteristics. Those we're kind of born with that we can't, they're not decisions. I don't decide to have long hair. I don't just, things like that are immutable. Race, color, creed, national origin, religion, things like that need to be proactively protected to make sure that we're all treated the same under the law. And those are the things that we tend to fight for. Some people think we're fighting for civil liberties. Well, we're usually fighting to protect them. We don't want the government to do overreach and injure those inalienable things that we consider fundamental, God-given or humanitarian rights. But rights are the ones that the government actually takes that proactive stance for. I like how the book talks about the fact that rights should be promoted and protected and thought as the foundation of a civic life and a free society in order to give it sort of any kind of credence or value. And the book starts off very, very, I think, strong in that aspect and treated equally under the law. But we know when it comes to civil rights, we've come really a long way under color of law, meaning in terms of legal fashion, it's going to be very difficult for anybody. And maybe that should be the discussion board question for this week. Are there any laws that discriminate against any one group or individual that isn't justified? I always think about age with me. One time I thought about becoming a state police officer simply because my father always thought that was the best job in the world in terms of benefits and how long you have to do your career before you retire. And of course, I didn't want to leave school once I fell in love with it. The love affair wasn't so great in the beginning, as I told you guys before. But later on, I really didn't want to leave college, and I wanted to keep going and get my law degree. But I was always toying with, and I took the exam several times for state police, and I was on the wait listed and things like that. Well, guess what? I can't keep that option anymore. Why? Because I'm discriminated against because of my age. Validly so. And so my point is sometimes we do allow for discrimination, but the government has to have a valid reason for doing it. And we'll get into different kinds of tests depending on the nature of discrimination. But generally speaking, our country did not start off with very egalitarian and equal access views as much as we thought maybe. We get excited over the Declaration of Independence. I do, and I know when I certainly get very much inspired by some of the writings of our early framers of our government, but we know they weren't including everybody in terms of equal access or equal application of law, and certainly of public benefits and rights. There's no way it was equal. In fact, we know that it only applied to usually white men of a certain age, too. We discriminate against very young people to participate in democracy, and we still do to this day. Women couldn't participate. They weren't called Americans then. They were actually property. And I'm not saying that to be derogatory. I'm just saying that's a fact. They were not called African Americans at that time. They were called African slaves. Certain religious groups weren't allowed to participate in civic life and were treated unequally under the law. So the point is, over the decades and over the centuries, we've really come much closer to the aspirational goals of due process of law for all, equal protection of law, and that all men and women, all people are treated equally under the law is truer now than it ever has been in our history. That's the good news. The bad news is we know we still have what we call de facto discrimination on significant levels, and certainly in the private realm as opposed to public. And the question is, should that even be something that the government should delve into? I'll get to that in a moment. So we talked about what is a civil right versus what is a civil liberty. All persons similarly situated should be treated equally and alike under the law. That's sort of the definition of what rights mean. And it's kind of think about it. If I think I'm being treated unfairly vis-a-vis my brother or sister, and I mean that in a figurative term, we use that in law quite a bit when opposing counsel, I can't remember their name. If it's a female, I say my sister. And if I see a male attorney and I can't remember the name, I say my brother, and that's a colloquial term we use in court sometimes. We get mad and we say that's a violation of our fundamental rights to equality, especially in the public forum of law or access to public education or public housing or benefits. We all should be treated equally under the law. And that's all we ever usually aspire to. We're not a society that usually adopts the view that we should have equality in outcomes. Some people do believe in that, sort of a communist outlook or a seriously liberal form of socialism is that concept we should have equality in outcome. We should have similar living standards in our homes and in our clothing and our dietary access to good foods and things like that should be all equal across the board. We don't usually believe in that as a society. What we do believe in, though, is what? Got an equal chance at it, right? You got an equal chance to get educated in the public system. You're going to be treated fairly under the laws, just like everybody else. You're not going to be targeted to prosecution while others are ignored under the law. It's equality. That's all we ask for in terms of opportunity. That's usually the expectation we have. We don't expect that some people aren't going to out hustle and work other people. Some people are more gifted in terms of brain or creativity, and they're probably going to maybe make it farther in life. We just want everyone to have an equal chance, and that's I think the philosophical conception. The book does get into that later when we talk about political philosophy. So they came up with 3 tests. So basically, can the government, now I'm talking about just the government at this point, can the government ever discriminate? Yeah, just give you the example. I'm too old to be a state police officer. They will not let me do that. And some would argue, well, that's discriminatory. Yes, but does it have some validity? Yeah, I'm in my 50s. Am I going to be able to chase somebody down the same way as if I was in my 20s? If there was a physical aspect to the job, and there is certainly, I would think, a physical aspect to most state police work. Is my eyesight the same? Think about being a pilot. Should somebody who doesn't have very good vision be allowed to be? Is that discriminating against people with impaired eyesight? Yes. Sometimes we allow discrimination in certain realms of the job. One of the jokes my friend and I were involved in, I used to go to horse tracks when I was younger with the 2 of my deceased friends that I just got done talking about. And I was much heavier back then, but I'm still a pretty heavy guy now. But one of the jokes was there was like an apprenticeship program for jockeys, and they wanted to see if I would go and apply just to see what happened. Because at the time I was close to 350 pounds. I'm like 6'1.5". There's a big, huge guy, and obviously I'm not going to be a jockey because jockeys need to be tiny, need to have like a very decreased weight. Could they discriminate against me because of my weight? Of course they could, and rightly so. So my point is, there's 3 tests that got developed depending on the nature of the discrimination. And where do they come from? It's not in the Constitution. The laws in the Constitution have evolved to try to give equal access unless the government has an interest in doing otherwise. The first test they have is if we're going to discriminate on different types of things for different situated people, the government has to have, the first test is called rational basis. That usually relates to age discrimination or discrimination against other kinds of characteristics other than sex, race, religion, ethnicity, those kinds of factors. So it's called the rational basis test. And basically the government has to show, hey, do you have a valid reason for the government to discriminate between these 2 different groups of people? If they can justify it, the discrimination is allowed. And those are usually those kinds of cases that come up and say this group's being treated different than this one, but it's not because of age, not because of sex, and not because of ethnicity, religion, race, things of that nature. It's usually something less suspect of a historical wrongdoing that we recognize. And it's usually related to age. And usually that's the best one. If you can think of examples, like we discriminate, we don't want very young people driving cars when they're 7 years old. I always love those humorous stories where you see some kid getting pulled over a road. He turns to be like 7 or 8 years old. Why don't we think they're not capable? They don't have the maturity or the hand-eye coordination to, well, maybe they do hand-eye coordination, but the length of their body is not going to be able to touch the brakes and things like that. And the same with flying a plane or getting a gun permit, things like that. We discriminate in age. Voting. I'm already mad enough that my 20-year-old has the same power to vote as I do, because he's probably going to make an unwise decision. Pardon me for a second. My dog is whining at the door, driving me crazy. All right, I'm back. So, rational basis test is for discrimination usually based upon age. I can't think of any other off the top of my head that would come into that category of rational basis. And where did this rule come from? The courts. And we know we're going to talk about that later when we get to the judiciary. There's this thing called power of judicial review. When the courts determine whether something is a violation of a constitutional principle, like the Equal Protection Clause in the 14th Amendment, it determines what kind of test or evaluation is appropriate for the court to determine whether or not it's constitutional or not constitutional. And the test for age discrimination has been the rational basis test. And just like it sounds, it has to be rational. That's it. The next one, usually related to sex discrimination between men, women, and different sexual identities, has usually a heightened degree of scrutiny. And there they defined it as, there the burden of proof is on the government again, but it's got to be substantially related to not just a government purpose, but an important government purpose. And there's no real other way to attain that outcome without causing huge expense or burden on the government. Believe it or not, Ruth Bader Ginsburg, who recently passed away, was involved in one of those first major cases, because before that, sex discrimination between different sexual groups' identity, was only the rational basis test. She was the one that managed to get the Supreme Court to buy into the historical discrimination between men and women, especially in employment areas, that they needed a heightened degree of review, one that's more skeptical of what the government's doing. And that's called intermediate scrutiny. It's in the middle. The third one, which is the one most people seem to like to talk about if we're in a live class, is called strict scrutiny. That's when we treated people differently because of race, color, creed, national origin, and religion. There, we call it the government needs a compelling reason for why they're discriminating. And the law needed to be narrowly crafted to not discriminate carte blanche or widely, to be as narrowly crafted as possible. And the government can't find any other way in which to meet that outcome. It's almost never been upheld. So the point is if you're discriminating, government this is, on race, color, creed, national origin, or religion, the government bears the burden, and it's a heavy burden, almost impossible to meet. However, they did meet it one time in the 1940s, which surprises a lot of people, when Japanese Americans, who have committed no crime, actually no evidence of them committing crime, they were citizens of the United States, they were put in internment camps for the period of the war. Concern was that the Japanese Americans are just Japanese by heritage because their parents are Japanese and they have Japanese DNA, I guess. We better lock them up. Sounds to me like we're treating Japanese people, ethnicity or race, differently than we're treating Caucasians. What did the Supreme Court say about it? It's called Karamatsu. I wrote a pretty big paper about it once. I love this topic. The Supreme Court decided 6-3 that it did meet the strict scrutiny test because the safety of the American national security was at risk if we didn't, especially in the West Coast, didn't inter these people during the duration of the war, because there was real suspicion that their loyalty might be more with Imperial Japan than it is with the United States. Although Karamatsu lost the case, and technically the case is still good law, most people recognize, and currently everybody on the Supreme Court, when they comment about Karamatsu, said it wouldn't survive review today. We've come a long way in understanding that that wouldn't fly. In order to have a free society, we have to let people go. After 9/11, did Muslims groups often feel that the government were targeting them and were making them more suspect to scrutiny? Yeah, and the thing is anytime the government tried to do anything overtly and formally, got shot down as unconstitutional because it violates the Equal Protection Clause of the 14th Amendment to the United States Constitution. So putting civil rights in the Constitution, took a long time, and it's evolved over a great deal of time. In fact, arguably we fought over civil rights an entire civil war between the North and the South because of slavery. Well, it was a big part of the slavery was definitely the vehicle, but it was also about the federal government being dominant versus the states having autonomy to make certain decisions within their hemisphere of authority, if you will, who really has authority. But let's face it, a lot of it had to do with slavery, and a lot of it had to do with civil liberties and rights. When we get to the Civil War, just prior to it, and some people think it's the straw that broke the camel's back as a case, and you should know it for test purposes, is the Dred Scott decision. Now, are there other groups and peoples that have fought for civil rights throughout our country's history, even before African Americans? Of course. But the most severe part of our history, the most overt and in the open and in our face that we have to discuss was slavery. I mean, people were put in bondage against their will. And they were brought to this country without any kind of voluntary assent. They weren't indentured servants. That's a contract. So it was a very brutal practice, and people started fighting for its abolition. The North, especially the Northeast, abolished slavery pretty much at the inception of the Revolutionary War, but certainly shortly thereafter. Many people think it's because we're more enlightened. We realize the horror of it, and we're going to be more egalitarian, and we shouldn't hold people in bondage. There's some truth to that. There were some groups that did that, but many of the groups also recognized that slavery just didn't really have an economic viability in the Northeast. South, it was the engine of the economy, and the southern states didn't want to give up the slavery, and that's the tension as we started going west. What states will come in as slave states, what states will come in as free states, wasn't always about slavery. It was whether or not the South would dominate political affairs or whether the North would, because every time you get another state in the Union, it would become a voting member in the Senate, 2 senators, more members of the House of Representatives. And if they're a slave state, they more identify with sort of slave owning dogma and ideology versus the North, which was more commercial and less inclined to believe in the institution of slavery as an appropriate institution at all. So that tension was always going there. But right on the eve of the Civil War, we're starting to fight over this question of the Missouri Compromise and whether or not we're going to let certain states in as free states or slave states. What are we going to do? This guy, Dred Scott, an African-American male, lives for a period of time. I don't know if it was in Minnesota or Wisconsin, but he argued that because he was brought into a free territory and a free area, meaning no slavery was allowed, he somehow became emancipated as a result of living in those areas, and therefore he couldn't be put back in bondage and brought back to a southern state that allowed slavery. Went all the way to the United States Supreme Court, and a couple of horrendous rulings came out of that case. The first is that Dred Scott didn't even have standing. I mean, he didn't even have a right to be in the court. Why? Well, because he's not a person. He's not a citizen. Why? Because African Americans weren't, this is the grossest part, I think, of the case, in terms of humanitarian outlook, they weren't even people. They were property. And because they're property, they don't have standing. Only persons have standing before the court of law, and they're not even citizens. So even if they are a person, even if they're freed and got their freedom from whatever mechanism, manumission, meaning the owner basically gave them freedom, or they were born into a free status, they weren't citizens. They didn't have a right to vote. They didn't have a right to even be on juries, maybe own property, enter into contracts, all kinds of limitations on their existence. So the Dred Scott decision said they're not only people, they're not people, they're not citizens, certainly, because only people can be citizens. But the last most troubling one is they're property. And if you're property, just like if I own a watch, this watch here, my cup of coffee, it's property. What's one of the things that's sanctimonious in our society, even at its inception? Life, liberty, and I know it says the pursuit of happiness, but John Locke's philosophy, that was in our framer's mind, the protection of personal property. So if these things are protected by the government, it would also include slaves. So if I'm a slave owner and I'm living in Mississippi or South Carolina, and I decide I want to move to Wisconsin or California, I should be able to take my watch, my cup of coffee, my eyeglasses, my clothing, and my slaves, because they are property like any other property, because the government can't deprive it of me without due process of law, and there would be no valid reason for doing so. And that's what the Supreme Court ruled. And it kind of shocked the abolitionists, and especially in the Northeast, were so outraged over Dred Scott that the tinderbox was already igniting over the North and the South, because Dred Scott basically did away with the Missouri Compromise. Basically, so the Congress had no authority to rule some regions to be free and some regions to be slave. And it really, basically, slavery, it opened up the concept that slavery could be brought back anywhere in the country again. And it's like, holy crap, things are really going to become explosive. And we know shortly thereafter, Lincoln, although not a real abolitionist, but a Republican, and many of the Republicans were what we call radical Republicans, were also abolitionists. The South just saw the end near and didn't want to be part of the Federation anymore. They wanted to be an independent country of their own. And some of the states started basically succeeding, basically say, I quit the club, I don't want to be a part of it. And they joined their own sort of soft club called the Confederacy. And thus the Civil War broke out. But believe it or not, Dred Scott still haunts us to this day in terms of the mentality of that not only are blacks, African Americans, Africans not citizens, but they're not even human beings. They're property. So, hey, the Civil War. A lot of people think the Emancipation Proclamation frees the slaves. It's not really true, and Lincoln knew it was true. And I think I'm going to put up a little clip from Lincoln, the movie, with Daniel Day-Lewis, which was very good. It was really about the 13th Amendment more than it was about Lincoln. It was the ending of the Civil War. But during the Civil War, the famous Emancipation Proclamation, everyone thinks Lincoln is being this real noble guy. He's going to free all the slaves. Part of it was that, but he wasn't freeing them all. He was only freeing them in those states that were in rebellion as a military tool, saying, I'm the commander-in-chief, and during this insurrection, I'm freeing all the slaves in the southern states to help with the war effort. He said it in much more eloquent terms, of course. And Lincoln, being the brilliant guy he was, knew that his decision was constitutionally suspect because the Constitution actually recognizes slavery, or did. And there were several states, Maryland, Delaware, and a couple were already in control of Union troops. It didn't free the slaves in those areas. So slavery did not end with the Emancipation Proclamation. And as the war was coming more towards a close and the Union was going to clearly win this thing, Lincoln said before the South comes into voting, comes back into good stead after Reconstruction, we need to get something passed that bans slavery. He turns during the course of his presidency from being, he actually thought about, can we send all the slaves back to Africa? Can we set up their own, kind of like a sovereign nation within a nation, like some of the Native American reservation systems that we make later on. These questions were suggested that he wasn't exactly progressive as what we think of today, but over time he did become an abolitionist. He did see that it was a scourge on our society, that it had to end. But the only way to end it constitutionally, legally, was to create the 13th Amendment to the United States Constitution. And it wasn't, everyone says, Lincoln passed the third. No, it was, the country passed the 13th Amendment based upon his driving desire to get it done. And he needed what? He needed basically 2/3 of the states to amend the United States Constitution. That's a standard. That was on your previous test, I hope, or it's not certainly going to be in the final. You need to have 2/3 need to recommend a change to the Constitution, or 2/3 of the House and 2/3 of the Senate have to make that recommendation. But then 3/4 of the state have to agree. Well, which 3/4? Those that were still part of the Union had to agree. And they knew he had it, and he was fearful that after the Civil War, when the southern states came back into the fold, they wouldn't vote voluntarily to support the 13th Amendment. So the 13th Amendment, you should know it. It frees people from any kind of form of indentured servitude and slavery. That's why you can't force people to keep a job. Like, I signed up for a year, but I quit. Can you quit? Yeah, you might have to pay damages, but they can't force you to continue working for them because that's banned by the 13th Amendment of the United States Constitution. What's interesting here in this era of the 1760s and going into the 1770s, is women, probably more than any other block group, fought for abolition, fought for the end of slavery, saw it as repugnant. They fought so hard for that cause. And along the way, what did some of those leaders of the abolitionist movement, women, recognize? We're really getting shortchanged. We're fighting for this great cause, and yet we can't even participate in civil life. In fact, much of our property is owned by our husband, don't really have the right to divorce. Things usually have to go through the husband's okay first. Back then, husbands couldn't be charged with a crime against the wife. they really were getting a second-rate treatment as well, too. Not to mention Native Americans. Native Americans never had any rights. In fact, Native Americans also weren't deemed citizens of the United States. You'd think they would be the first citizens, but they were deemed not to be citizens really up until the 1920s, where they finally recognized, because there was this argument they were put on sovereign, meaning their own country within a country. How could they be citizens of the United States? They're also citizens of this other country. It's a legal fiction that really put them behind the eight ball for purposes of being treated unfairly and not letting them really participate in civic life. But African Americans, we know after freeing them from slavery, they were treated in a different form of slavery especially down south, because the southern states weren't really much inclined to let these people participate, and they still banned them from voting and going to public schools and to being on a jury. And even if on token level they suggested that there was equality, they would do things like a poll tax, which they couldn't afford to vote. They couldn't, or a literacy test that was only applicable if your grandfather wasn't allowed to vote. Well, African Americans, obviously their grandfathers weren't allowed to vote, so they had to pass a literary test, unlike illiterate whites. Illiterates didn't have to pass a literary test because they were grandfathered in. That's where the term comes, because their grandfather previously was able to vote. So anyways, they get the 13th Amendment. Great. Freedom, but freedom is kind of hollow if you can't work and you can't own property, you can't get a job, you can't become educated. So, and the laws of the individual states still discriminated against them so significantly, it created a second tier of bondage. They basically had to go into a type of servitude that was really equivalent to a slavery. You just had the freedom to walk away from the job, but where are you going to live? How are you going to eat? How are you going to survive? And then Reconstruction took place. It's really from 1865 to 1877. During this period of Reconstruction, the North dominated the South militarily, and they forced down the throat of the southern states, and I think rightly so, Reconstruction platform, in that they created a bureau called the Freedmen's Bureau, just like it sounds, was to help freed African males, especially to eat and to live and to find housing and to set up some schools. Things like that really happened. And shortly thereafter, the recognition freeing the slaves in the 13th Amendment wasn't enough. We needed something else to prevent states from denying anybody, blacks or whites, fundamental laws that are out throughout the United States. And thus the most powerful amendment, if you ask me, a lot of people think it's the First Amendment, freedom of speech. I think it's the 14th Amendment. I think it's 1868 gets passed. That amendment said basically no state can deprive its citizens of equal protection of law and due process of law, which has been interpreted to say certain fundamental rights have to be equally given to all people, black or white. And it was very much imposed upon the South during Reconstruction. African Americans started participating in civic life. They ran for office. They won office. In fact, several South Carolinian members of the House of Representatives were African Americans during the period of Reconstruction. Why? Because the South were dominated by federal troops, and therefore African Americans could get a certain degree of protection to participate in civil life. They were still not allowed to vote. 14th Amendment, even though I think inherently suggests equal protection law, was one of the inherent things under the law, the right to vote. Many of the southern states were still not allowing it. They were banning it outright. And so they needed the 15th Amendment, that no state could discriminate between a male's race, color, creed, national origin, but still women. Still, you could discriminate against women until 1919, basically 1920, 100 years for the 19th Amendment to get passed. But the 15th Amendment, so now, do we have equality with African Americans? No, we still don't have equality today between certain groups. But in terms of the law, did the law finally come around for African American males to recognize they should have the same equal access to society's basic institutions? And the answer is yes, in the eyes of the law. But like anything with law, can law be misapplied or applied with undue weight for one group for another? Of course. So the battle continues, and we know it went right up into the 1960s until it really, really took hold. But those are you should know those three big amendments to the United States Constitution, which are called the Civil Rights or the Reconstruction Amendments. The 13th freed African Americans from slavery, or anybody from slavery. The 14th Amendment created due process that the states can't fundamentally deny their citizens fundamental rights, nor can they do so without a procedure that's fundamentally fair. That's the process aspect of it. And then the 15th Amendment can't discriminate on people's race, color, creed, or national origin for voting purposes. Those are the big reconstruction of the post-Civil War amendments to the Constitution that tried to create what? protection of rights. That's what the chapter's about. Did it? No, because the South got very creative. I mean, the white South, not everybody in the South that were white were like this, but those that were still very racist and very bitter over the Civil War were still kind of fighting it in a different method, and they would try to create every possible schism they could to make it difficult for African Americans to participate. But did they? And this thing a lot of books don't talk about, and I don't think your book talks about it so much. During the period of Reconstruction, right up until 1877 and right after the Civil War and the 15th Amendment was passed, African Americans did actually participate a great deal in the South in civic life. It's almost a period of Renaissance. It's kind of like very rapidly African Americans were put into sort of a seat at the table, so to speak. So what the hell happened? This is one thing your book doesn't cover too well. U.S. history does cover it well. My class, anyways. I think most books cover it well too. Reconstruction finally ends. What happens? There's a big race, and it's a very controversial. Rutherford B. Hayes becomes our next president. He's a radical Republican. In that era, the Republicans of that era, especially the radical Republicans, wanted equal rights for African Americans. It was the Southern Democrats were a national party. The Northern Democrats were more like the radical Republicans in terms of some of that ideology, but the Southern Democrats were staunchly against desegregation and integration and equal rights for African Americans. They thought they should be treated differently. So what happens? Rutherford B. Hayes comes into a really a close race, and I can't think of his opponent in the Democratic Party. The Democrat probably won the race in terms of the electoral college vote, but there was a lot of fraud going on. People were stealing ballot boxes, throwing away the things. I mean, this kind of argument still going on to this day over who wins and who loses. But as of the compromise, it's called the Compromise of 1877, they basically said, we'll let the Republican win the presidency, Rutherford B. Hayes, not a radical Republican by any means, but you got to take all the military, all the Union soldiers out of the South, let the Southern states run their own states, and what we call Reconstruction, the dominance of the North in the Southern region. Okay, and once we did, what happened? Groups like the Ku Klux Klan, other groups created Jim Crow laws, basically making it fundamentally difficult for African Americans to participate in civil life. There's no question about it. It really was a sad departure from what we saw signs of in terms of success. But if you're a states' rights person, you're going to say, but at some point Reconstruction had to end. Is the North really going to dominate the entire country? It's not really fundamentally fair. The South has to come back in and just simply follow the law. But did they? No, they didn't. In fact, they had to create other laws to crush things like the Ku Klux Klan and other discriminatory practices in the South. And those lasted right up until the 1960s. John Lewis, I believe, of Georgia, but at one time spent time in Massachusetts. That's the guy that got really skull cracked open just on a peaceful march. Why was he marching in 1960 if we had all these rights already fixed in the 1880s and 60s and 70s? It's because they weren't really applied, and people were getting really shortchanged. And we know that, still speaking of race, we know that African Americans didn't have the same access to the same public entities and facilities and services as whites did, because we had segregation. Segregation was deemed illegal right up until 1954. What do I mean by segregation? All the 14th Amendment says equal under the law. It doesn't say anything about keeping us together. So therefore, you can segregate schools. You could have an African American school. You can have a school for whites. That shocks us today. But 1954 wasn't that long ago in the big picture of things. Less than 100 years, certainly. About 80 years. Actually 70 years, very recent history if you really think about it. The South, and even in some places in the North, they had all white schools. And I'm talking public now. Private's different. We'll get to that in a minute. So it was challenged in 1896 in Plessy versus Ferguson. It wasn't about schools. It was about pull cars. Basically, they had cars on a train. Some were for whites and some for African Americans, but they were identical cars. Just some were for blacks and some were for whites. And blacks challenged it, saying this is a violation of the equal protection of the law. We should be able to go into any car. We're citizens. The court, not a unanimous decision. Harlan, I believe, Justice Harlan dissented and later becomes sort of the mouthpiece of the argument that separate but equal is always inherently unequal. And he's right. But anyways, he was a dissenting opinion. In 1896, they said, no, it's okay because it only requires equal, and the boxcars are exactly the same. And so, therefore, all the way up until 1954, in public accommodations, public schools, public hospitals, public train services, buses, all those things, the government could discriminate on where you had access to things as long as it was equal. The problem is study after study after study started showing that when you separate races and give them different public institutions for schooling and things like that, it will be unequal. And it also creates a certain social and psychological stigma of different groups by being required to be away from others. And then comes along the case of Brown versus the Board of Education. Thurgood Marshall, not John Marshall, a different Marshall, Thurgood Marshall, the African-American first Justice of the United States Supreme Court, was the attorney that helped advocate in Brown versus the Board of Topeka, Kansas, saying separate but equal doesn't work. Yeah, we know we have this case from 1896. It's time to flip it. And that's when it really did. Now, did overnight, as a result of Brown v. Board of Education, suddenly give African Americans the ability to go to public schools? No, a real nightmare situation happened where the states, especially the southern states, did almost nothing to integrate their schools for the longest period of time. In fact, I can remember, and I'm a product of busing in Springfield, Massachusetts, it really took almost another 20, 25 years before the courts put teeth into that decision to require schools to physically take people, because all the people, there was white flight. White people would send their kids to a public school, but in a white neighborhood, and black kids would go to schools in their neighborhoods, and therefore there wasn't really truly integration going on. And busing tried to fix that. It's got a mixed history. I know when I was a kid, I remember my father, who I think of one of the most thoughtful and fair-minded and open-minded people, believes in he's dead now, but believed in integration, believed in fair play for all, outraged by some of our history. He hated busing. Why? Because I literally grew up next to a school that was right down the street from us, and I was removed from that to go to a different school on a bus so I could be mixed with more of the different ethnic and racial groups within our community. The problem is that sometimes the remedy is almost so draconian that it leaves a bad taste in their mouth. And a lot of people think the Northeast very progressive. Boston rioted in 1970s over busing, and Ted Kennedy, who was for busing, thought we needed integrated schools in order to have an equitable society. Ted Kennedy got spit on, and people were throwing things at him because he thought it was appropriate to have busing. And a lot of people in Boston were not so keen on mixing of the races and forcing people out of neighborhood schools. Really a mixed history after Brown versus the Board of Education. And so other cases come along with Japanese Americans. There's a case of Shelley v. Kramer, where private, interesting one of our justices at one time, Justice Rehnquist, owned a home, and in his deed it actually said that any subsequent owner can't be a Jew, an African, a Mexican descent, all these different things, because they wanted to create a neighborhood that was white. Well, the Supreme Court did an interesting thing. Well, that sounds like a private covenant, right? So I say I own property right here, and I'm a white supremacist, and I say, you know what? If I'm going to sell it to the next owner, I'm going to tell that next owner that in perpetuity, the property needs only to be owned by people of a Caucasian, Anglo-Saxon heritage, and maybe I'd list them out, and I list out the ones I don't like. That is a private covenant, and usually the government doesn't get involved in sort of that private like and dislike kind of a thing. The thing is who would have to enforce it? A court. And isn't the court an extension of government? Yeah. So in that famous case of Shelley versus Kramer in 1948, the Supreme Court of the United States says, although those covenants are a bond between the two contracting parties, the court will not enforce that bond. By enforcing it, they're enforcing something that's repugnant to the mandates of the United States Constitution. I thought that decision was fantastic. But sometimes if you're really interested in, the racial disparity and civil rights in our country, you can pull up a lot of deeds, especially in the South and even in the Southwest, where there was a lot of these restrictive covenants banning people from selling their real estate to certain religious groups and races. Racism alive and well back in the mid-century of the 20th century. Some people think it's alive and well now. But in terms of law, that's probably what I'm going to put up in the discussion board. Where in the law do we allow discrimination based upon race, color, creed, national origin? I don't think we do, but do I think there's still plenty of discrimination going on? Yes, but it's more insidious. It's more outside the scope of legal mandate. So that's one case. And the other next case it talks about in the book is Loving v. Virginia. There's a pretty good movie made about it. I think there's several movies made about it. White guy falls in love with an African-American girl. She falls in love with him. They're down in Virginia. They decide to get married. And those of you that in my family law class or had my family law class know that they both got, I think they got a short jail sentence. They never had to serve it. And they didn't care. They purposely did it knowing they'd be charged. And they were charged under law. And I love how the government of Virginia tried to argue, oh, we're not discriminating. We're treating white people equally as black people. Both of them are committing the crime here. And they'll both be punished equally. The problem was it treating people because of race differently. So two Caucasians could marry two African Americans, but you can't marry outside your race. And the other justification, besides being equal, the argument was by the state of Virginia, was it was for the purposes of keeping the purity of race, as if that's a noble thing to do. And the Supreme Court said, no, nonsense. If you're adults and you're voluntary entering into engage, in the arrangement of marriage, it's totally legal. And back in that era, it was a shocking decision. We don't think of it as shocking as all today. So we've come a long way, and I think that's a positive thing. Is there some negative things to this day related to it? Of course there is. Legislating civil rights. So then a 24th Amendment came in, which finally banned poll taxes. Poll tax basically, hey, you want to vote? You got to come in and vote. But if you didn't pay your poll tax for the previous years and you've been able to vote for 30 years, you might owe a fair amount of money. Who has been historically behind the eight ball financially? Well, African Americans through the discrimination process. So it was a way in which to keep the vote more likely in the hands of not only white people, but more affluent white people. Democracy wasn't nearly as pure as it has been in our history. For a lot of different people, wealthy white men usually ran this country. Women are still out of the picture, and African Americans, although allowed to, they're putting these Jim Crow laws into effect, like the literacy tests, and then the other one being the poll tax. I'm trying to think of some of the other ones. So the 24th Amendment of the United States Constitution ended that. 1966, Harper versus Board of Education. That was for state elections as well as federal. Yeah, so government discrimination on voting qualifications by race outlawed segregations in the other form. Now, this is huge. Okay, so in 1964, John F. Kennedy gets killed. If you can see my political buttons behind me, they're mostly John F. Kennedy buttons. Yes, okay, I like him. All right. But I'm not saying that I didn't recognize some of his faults. And he was a little bit slow on civil rights, quite frankly. But slow for 1963, he was moving forward. There's no question about it. And he was starting to propose some civil rights legislation because the tensions were rising in the country. He had to deal with it. Unfortunately, he gets assassinated. But in some ways, the Civil Rights Act might not have passed without his assassination. He's martyred. The country is grieving over this guy. They want his sort of agenda maybe to go forward as a result of that kind of emotional outpouring. And Lyndon Johnson, although a Southerner himself, was surprisingly progressive on civil rights. And so he wanted to get the 1964 Civil Rights Act passed quickly in honor of John F. Kennedy. And he did. And here's what's interesting. Now it's no longer... Now, what do we know up until this point? It's illegal because we have rights as whites, as blacks, as Puerto Ricans, as Hindu, as Indians, as all kinds of whatever race or ethnicity you are, you have to be treated equally under the law. That's pretty much the law right up in that point. In terms of government access, public schools, public transportation, rights to vote, all of those things that we think of as fundamentally government sort of controlled institutions have to have equal access. What about privately? That's where it all changed in 1964. In 1964, the Civil Rights Act passed, and now, based not upon anything in the Constitution other than the Commerce Clause, any business, any kind of private entity that impacts, which is a very broad concept, commerce can be dictated to under the Commerce Clause of the United States Constitution, under the Article 1, Section 8. And so they used the Commerce Clause to dictate that any employer that has 15 or more employees and impacts interstate commerce can't discriminate on race, color, creed, national origin, religion, ethnicity, sex, age, all of those things, unless they have a real bona fide purpose, which is going to be rare, again, when it comes to race and religious identity. I mean, I don't know what the Well, I couldn't see it. But again, why didn't they do it for every business? Like in a small law practice, say, I got 3 attorneys working for me. I got 2 other paralegals and 3 secretaries. I'm under 15. Why shouldn't that law apply to me? Can I discriminate if I have less than 15 under the federal law? Believe it or not, I can. Why do you think the federal government did that when they passed the legislation? Well, they did it because they recognized it wouldn't pass probably otherwise, because they didn't want to affect the mom and pops of very small business entities to be forced to potentially hire people that they would have to work with in close proximity that they really disliked. Once you get to a certain size, the justification for allowing discrimination gets lost, and it was more acceptable to members of Congress when they were trying to pass that law that it had to be of significance, that it had 15 more employees before the Civil Rights Act of 1964 was applicable. So now anything to do with a public accommodation or impacting interstate commerce, so restaurants, hotels, travel, and these businesses, none of them can discriminate anymore because of race, color, creed, national origin, sex, age, and all those things, unless they have a bona fide purpose, which is almost never when it comes to race and ethnicity. And that very controversial. There's no question about it. Now, what do? Say I got 30 employees. What if I don't have any African American people working there, but my community is represented by, say, a 20% population in there? Well, if I can justify it, maybe I can say I just haven't found anybody qualified. It's not because of discrimination, but there's certain presumptions we put in the law, and it's up to the accuser has to prove their case. But if I have a company of 1,000 people and I'm in a community and I have different levels of employees, really entry level, they don't really need any strong skills or attributes, all the way up to very highly educated people that degrees and certain technical skills are required, I think it'd be pretty difficult for me to overcome the presumption if I have 1,000 employees and in my community of my employment area, it's 20% African American and I have not one African American working in my company. What does it sound like on a presumptive level? Probably discriminating because of race. But small companies, again, don't have to abide by this law. It has to be over 15. Does that mean you have to have a quota system? No. It just means you can't overtly discriminate. Could it be possible that every time I came in, for whatever characteristics that came into the company, that no African Americans either applied or they did apply, they didn't meet the same kind of other standards that other groups met? Maybe, but I think it'd be a tough burden to prove that. The continuing challenges certainly exist because it's called. So one is we have de jure discrimination. That means it's overt in the law. I don't know any laws anywhere, and I defy you to show it to me. And I'm not saying this because I think everything's perfect. Is there any law that's designed to create discriminatory practices in the United States? I don't think there are any at this state. Is there significant discrimination still going on? Yes, and that's de jure is in the law. De facto is meaning it's happening through what seems like a fair playing ground, but people are still finding a way to work around things to treat different groups unfairly. Absolutely. We know it's true everywhere. I'm a criminal defense attorney, and I can see it in the way in which things happen in the court. You're at a disadvantage if you're poor. Poor people certainly don't get equal access to the law, even though the law is the same for them as everybody else. But the application process has to be different. Hire better attorneys and things like that. You can't tell me law enforcement, and I'm not saying it because of immorality, but are they more likely to target people who live in certain communities that are often made up of more people of color? I think there's some evidence of that. So how do we do away with it is going to be the tougher question. And in the Voter Act right of 1965, which basically got scuttled by the Supreme Court in 2013, for a while, southern states were mandated by the federal government to create certain kinds of electoral processes in their state to make sure that African Americans mostly weren't cheated out of the vote. Why did the Supreme Court basically say that law can no longer be effective? Because southern states have now proven that African Americans are actually voting and registering and participating in democratic processes at a greater per cap or percentage level than Caucasians. So therefore, the need for the federal government to interfere in traditional states' rights issues is absent, and therefore the state should be able to free to run their own elections. The problem will come, perhaps, that southern states will start doing discriminatory practices in their voting again to put a chilling effect on African Americans, is the argument. But if they do, can the aspect of the 1965 Voters Act come back into play and have federal governments oversee those southern states' voting mechanisms to make sure they're fundamentally fair? Yes, but right now the need's not there. I would argue, I'm with the dissent on that 2013 case. The reason why African Americans are participating at a fairly decent level per capita, I mean, percentage-wise, with Caucasians, is the very reason they are overseen by federal government to make sure they're fundamentally fair. It's kind of like saying, hey, since we've had this guard dog in the chicken coop keeping away the foxes haven't been a problem. So it's time to take your guard dogs out of the chicken coop. I think that's the kind of bootstrap argument that the majority bought into. But the good news is the majority did say if there's proof down the road that southern states are creating discriminatory practices against different racial and ethnic groups, they can implement those provisions again. Now I've gone on almost for an hour. I haven't got to women's rights yet and all these others. But the women's rights movement has been around since the Revolutionary War. There's no question about it. There were letters found that women were starting to clamor for some role in civic life, especially since they participated significantly in the Revolutionary War, maintaining farms while their spouses were out at war, doing the homespun industry during the boycotts of the British goods. I mean, it's pretty significant. In 1848, there was actually a huge women's movement, and it was held in Seneca Falls, New York. And I went there this past year to visit before COVID. 1848, the group of women went there, and they created something called their own Declaration of Independence. And I think they called it, what do they call it? I should have underlined it in the book. They called it Declaration of, it was something very similar. And they lifted a lot of the language saying all men and women are created equal under the law and have the same rights and duties. And they list their grievances out just like we did against King George, but they listed it against the government of the United States and men. And I went to Seneca Falls, New York, where this convention was held. And there's a beautiful federal sponsored museum right there. And it was beautiful, and it really had a lot of history about the women's movement being much longer than it really suggests. And they didn't really get any traction. It'd start up and it would die down, start up, and they were often put aside, and they did so much for so many other groups. African Americans getting the emancipation through the 13th Amendment. Many women's groups fought for that. And when we get into the early industrial time, it's women's groups that fight for child labor laws. They also are in the lead in making sure tenement homes in these early slums that were being developed started getting sanitation and cleanliness and decency. Women's groups often fought for some of the great causes in our country's history, but they didn't get the right to participate directly. It didn't change until 1919 with the 19th Amendment to the United States Constitution. It's really amazing how long it took for women to get equal rights. Now, does that mean women still aren't discriminated against on some level? Yeah, but not in law. But there's some evidence they make, 74 cents on the dollar that a man does for the same exact work in terms of the same exact skill levels. I don't know how they know that, but it seems to be an accepted statistical bit of information that women are still discriminated in that. And let's face it, when you think about how many women make up the population, over 50% are voters in terms of the voting population, and they only make up 20 or 30% of the House of Representatives, and even less on the Senate. We've never had a female vice president or a female president of the United States, and it's really recent history since we've had females on the United States Supreme Court. But are we progressing in the right direction? In terms of equal access, I think so. But that doesn't mean it should, then there's that debate. Well, should we have like a quota system? Should we have a requirement that there's equal numbers of men and women in the Congress, equal numbers of men and women, or some relationship that's relative to the population? I don't know if we want to go there. That's up to debate, and you guys can certainly debate that. And then the different other groups besides women, and we go to LBGT. We know those rights are fairly rapidly developing in a big picture. It really started with in the 1960s, gays were almost criminalized. Well, they were up until Lawrence, which was 1993, Lawrence v. Texas. But there's a famous case, or not case, but event in, I believe it's New York City. It was called the Stonewall Tavern Riots. Basically, cops were arresting guys hanging out at this gay bar for being gay, and a riot broke out. It lasted for days. In fact, right down the street from me here, and my wife didn't know I knew the history of it. We stopped she wanted to go to this restaurant called the Stonewall Inn. And she goes, oh, it's because of the stones on the. Goes, no, it's not because I know the owners. I said it's in reference to the Stonewall riots. And she goes, that event over homosexual males being harassed by cops in New York. I said, yeah. And she goes, well, how do you know that? He goes, well, I know the owners, and they're very much inclined to support that cause. She goes, well, what do you mean? And I said, well, they're a married couple of two guys, and they're very much involved in the LGBT community in terms of advocating it. She goes, I never even heard of this whole history. Many of you might not have either, but the fights were pretty significant. In fact, in the medical field, it was considered to be, an unnatural mental illness to be a homosexual. It was mentally, you were a mental defect, and that's changed very rapidly. Not only have we recognized that they needed to be treated equally under the law, it's almost every law they have to be treated equally under, and that includes the right to marry. We know it started here in Massachusetts, but that was on each state level, and it created a hodgepodge throughout the nation under federalism, very confusing, but it became a federal issue under the 14th Amendment, and that famous case is called Hodges. I think it's Oberfell. I never can pronounce that name properly. And that was 2013, I believe. And basically, gays and lesbians have the same right, long as you're adults, to marry as anybody else does. And you can't discriminate in most states. And it's not necessarily a federal dogma yet, but I think it has been recently in a case, sexual orientation, identity, and things like that. There's no valid governmental reason or private reason, with one exception. If I'm a religious group, or if I have a religious ideology that conflicts with those views, then I have a religious free exercise in contrast with their free ability to identify with their sexual orientation might become a conflict. And I'm thinking of the Hobby Lobby case where somebody didn't want to provide for contraceptive because it was against their religious practice, yet the government mandates that you have health insurance. And they've found in favor of the religious exercise clause. But it's a very complicated case. I don't want to get too deep on that. Native Americans and their rights. We know there's a long, terrible history in the way this nation treated its Native Americans. We got treated by the invaders, and that were us. But there's some case law that actually rejected some of the acts that were happening to Native Americans, including the Worcester case. It's called Worcester. It has nothing to do with the Worcester County, or Worcester v. Georgia, where there was Native American Cherokee group down in there, and they had their own reservation. They had a treaty that said, this is our land, we can stay here. Georgian, Caucasian Europeans wanted that land, trying to force them out. They went all the way to Supreme Court. Supreme Court says, Native Americans, you win. You can stay there. The government can't force you out. This is one of the few times that the Supreme Court was completely ignored. Andrew Jackson was the president of the United States, told the state authorities in Georgia, ship them out. And they did. They moved them all the way out west into Oklahoma, beyond the Mississippi River, in direct contravention of law. And we like to think of our nation as the rule of law. And not only, that's terrible enough. It's called the Trail of Tears. I think they lost like 20 or 25% of the Cherokee population during that very difficult march. But there was conflicting ways. There were some people that really did care about Native Americans, and they would try to change the system from reservation system to individual plots of land and immersion into the culture to become Christianized. And for a period of time, some people had good intent, but they took kids away from Native Americans so they could be brought up in sort of like, I don't want to call them foster home schooling environments, so they can become westernized and become Christians, and therefore become sort of part of the melting pot. Tragic, tragic story. But what you guys consider in terms of law that should be tragic is Native Americans aren't citizens of the United States. You think they'd be the first citizens. They were actually not considered citizens until initially the 1924 Indian Civil Rights Act guaranteed citizenship to all Native Americans born after its passage. And then not really until 1940 were all Native Americans considered citizens of the United States. Really bizarre. They have this little story in the book, which is fantastic because I knew someone that was involved in it. In the 1960s, a group of Native Americans took over Alcatraz, the old prison system. It was already closed down, but the place wasn't really housed with any authority. So a group of Native Americans went there. Of course, the national government eventually shut off the electricity and the water, and everyone started suffering. And one of my friends, and actually a graduate of the Mount, his name was Roger, unfortunately passed away not too long after graduating. He was an older student. And he was one of the occupiers of Alcatraz Island in the Bay of San Francisco, to show, hey, it's time for some red power. That's what they called it. And I'm not using that term. I find that a little bit derogatory, but they didn't at the time. It's contextual at the time because they were looking for civil rights. Civil rights, the right to be treated just like every other person in this nation. And they haven't been historically, and they still aren't. Are just some degree in terms of how do we treat them. Are they sovereign? Are they independent? Are they part of the American culture? Are they both? And how do we make it fair and equitable? Same with Alaskan natives and Hawaiian natives. And I hope, okay, there is something on the Hispanics and the Latinos, and I guess there's a distinction between the two. I apologize if I can't always recognize them, but what's very interesting in the 1930s, less than 100 years ago, we actually deported a great deal of Americans of Mexican heritage in the Southwest that were competing for jobs during the Great Depression. A lot of people don't know that. It's pretty outrageous. And they've been fighting for equal protection in education, access to the same fundamental rights, including not deportation if you're an American citizen. Seems kind of wild that happens, but it does. And we know Asians' rights, and Asians too big a broad a cast, but because there's different groups within the Asian community that have been treated differently. But we know the first one after the train, when the gold rush began, and there was the Trans-Pacific, I forgot how you say the term. The trains were built on the western portion, right up to the middle of the country, largely by Chinese immigrant laborers, and they were doing quite well financially. They often did. They worked very, very hard, and they were welcomed for a period of time. Well, what happens after the train tracks are all kind of set up? Well, now they start seeking employment in other areas, and they seem to be a competitor with the other groups, Caucasians. And like anything else that threatens your economic viability, and if you're different, you look like you're different, let's pass laws to discriminate against you. And the first one we had was, it's such a terrible title, too. In 1882, Congress passed the Chinese Exclusion Act, which basically said no more Chinese can immigrate to this country. Believe it or not, if I'm not mistaken, that still is somewhat intact. It was given alleviation for about 1,000 people, I think, right after World War II, when Mao Zedong basically is pressuring Chiang Kai-shek, who was our ally, and they fought with us, arguably, in World War II on some level. And they allowed some, there was an exception made for some immigrants during that period of time. But there have been limits on Japanese Americans. That was a gentleman's agreement with Teddy Roosevelt and then the premier of Japan to curb Asian immigration. Kind of sad. And there are still caps based upon regions about who gets immigrated and who doesn't. People say, well, that violates equal protection laws. Equal protection law for the current citizens of the United States. This doesn't apply to foreign nationals that want to become citizens. And then we know the famous case I already went over with Karamatsu, and I jumped ahead. I did the thing. Karamatsu, Japanese Americans were, and there's no evidence. You can argue with me all day long, but I've read all the transcripts. I did part of my master's thesis on Karamatsu, where we incarcerated 110,000 American citizens who happen to be of Japanese descent, and there was no evidence of any sabotage, sedition, or anything else. And it was done very peacefully. And it's really surprising. And one of my favorite quotes, I didn't meet him, but I watched him on a live telecast once. He was talking about the argument was the federal government was putting the Japanese Americans in these campuses for their protection. And the guy was pretty funny. He says, if they're trying to protect me, why were all the guns up in the turrets pointed in towards the camp and not out towards the potential threats? We know it was I think we all can recognize it was a terrible thing, especially if you haven't violated any law or done anything wrong and there's no evidence of any wrongdoing. His last name's DeWitt. I always call him Charles Halfwit. He was the general, and he actually testified before Congress what the need was for this law. And he actually said, believe this or not, he actually said, the fact that there's no evidence of any sedition or criminal activity on these parts of these Japanese is reflective of how cunning and secretive they are with regard to their plots against us. Try arguing that in a court of law today. We have come a long way, so that's my point. We know, and I already went over the LBGT and those rights related to that. Civil Rights with Americans with Disabilities Act. Reasonable accommodations have to be given with disabilities. So if I had an office, for example, and I had someone who was, maybe unable to use their legs and they were in a wheelchair, could they still do a job at my office? Yeah, with reasonable accommodations, they should be able to do everything a paralegal needs to do. It has to be reasonable, though. So if I'm an airline company and I'm hiring someone to be a pilot or someone that's directing planes to be parked, and they don't have any vision, it would be unreasonable to have me hire someone to basically speak everything that's being viewed on the tarmac to a blind person. It has to be reasonable accommodations. And those are a lot of trials over that question. What is reasonable and what's unreasonable under the Americans with Disability Act? But most people believe that's appropriate. And we also believe that we shouldn't sterilize and basically castrate people with mental illness so they can't have further children. But then at the same time, there is an argument there that you want people with too severe mental limitations necessarily having children, knowing full well that it's going to create a pattern. That's the argument on the other side of those things. In religious minorities, we know that religious minorities are largely protected unless it's what? Unless it's going to create detriment to society. Very heavy burden for the government to show its reasons behind it. A ton of stuff in this chapter. I went too long. It's very scattered. Listen to me if you want. The book is excellent. Take your time reading it. It's a long chapter. Be well.